Hello, I'm Angela Princewill,
And I'm Sherine Abdi.
I'm Tabindah Barlas.
and today we'll be talking to you about divorce. So we're going to call this Divorce 101, where we just tell you the basics and some tips to help you avoid pitfalls as you try to get your divorce. So usually we would like to kind of define what we're talking about, but we figured no definitions needed here. If you're watching this video, then you probably know what you're doing. You're essentially trying to get legally uncoupled from your partner. So, on that note, I think we'll just dive right in. So, I think one of the main things that come to mind is, can I even get a divorce, right? So you might be upset and you want to leave your partner for what I'm sure are very valid grounds. But Shereen, I'm going to throw this at you. What are the grounds or the eligibility criteria for getting a divorce? It's actually called grounds for divorce, but yeah.
Yeah, so there's three grounds for divorce. One is that you have to be living separate and apart, and really there's no reasonable prospect of reconciliation. And that's for a period of at least 1 year. The reason that's done is because a lot of the time that people, believe that they'll be separated, sometimes they may get back together and they may reconcile. So that's why there's that 1 year period. There's also the ability to another ground of divorce, which is adultery and cruelty, where you don't have to wait the additional year. So those are ideally the three common grounds.
Okay. And all right. So when we're looking at, I like that you touched on the no reasonable prospect of a reconciliation, because the fact that you're just separate and apart, if you've attempted to reconcile, then that's obviously a factor. I know we've all had clients where they've attempted to attend counseling, and people misunderstand sort of what the intentions are there. So to be clear, if you're going to marriage counseling, there is a reasonable prospect that you could reconcile. If you're going to counseling to say co-parent, figure out how you could break the news to the children, and be able to support them through the process, then that's not the kind of counseling that would count as a reasonable prospect of reconciliation. But I don't know, Tavina, if you want to weigh in on an adultery, because that's a major one that people kind of like to rely on.
Absolutely. So I've had clients, unfortunately, there's a breakdown in the relationship, and they say, I found my significant or ex-spouse now cheating. And if there is any compensation, that they can get because they feel betrayed. I just want to say, Ontario is a no-fault state. So unfortunately, even though the circumstances might be where you're breaking up your relationship because of cheating or adultery, it doesn't really factor into you. You don't get compensated for being cheated on. So it's an unfortunate circumstance, but it is one of the reasons you claim a divorce, but there's no extra benefit to you should you choose to proceed. I do want to add in just very quickly on the separation part, the 1 year separation. You don't have to be the 1 year separation doesn't mean that you have to be physically separated from your partner. You can live in the same house, separate and apart. And as long as you meet the legal test, then you can still proceed with the divorce 1 year later.
Exactly. Yeah, that's a good one. And I think even with adultery, some people are like, well, I just want to be divorced right now. I don't want to wait the 1 year. Unfortunately, our legal system is not necessarily that efficient when you deal with the fact that the other side may deny it, and then now you having to prove this. I find that more often than not, it's not usually worth it. But obviously, some people just want us to set the record straight. It is the law. You could do that. Obviously, if there's been cruelty against you, it could be emotional. This doesn't have to be like physical cruelty. But again, these are grounds that you would have to prove. Living separate and apart, sometimes you do have to prove it, especially like when in that example where you're in the same home, or even people have lived in separate homes for convenience sake. For example, if someone's working up north and the other person's living, in the GTA, well, at what point did you become separate and apart? So as you know, everything can be open to interpretation, but those are sort of your grounds, and we'll try to make sure that you meet one of those grounds before we apply for your divorce. I think, Dimna, there's something you'd also mentioned to me before in terms of when people don't want to wait. You've also talked about sort of starting the process first, so you don't have to wait the 1 year to start the process if you're claiming other things. So if you feel, well,
Correct.
I want to file for a divorce today, it might be worthwhile to not necessarily, barring other issues, how the date of separation might affect other issues. If the only concern is, well, I want to be able to get my divorce in a year, but you're dealing with other issues that might take longer, then we've often advised clients to say, we'll tick that box to get you the divorce, because while we're in this court process, we might get to that 1 year mark. So
Exactly.
another thing that people often, one misconception is, we have to go get divorced where we got married. Has anyone ever seen that happen?
Often, I think they're like, oh no, I have to go back to India because that's where I was married, but I don't even live there. I only really got married there. The reality is it doesn't really matter where you were married. Like, you didn't have to be married in Ontario to get a divorce here. It really is just that the only test that you have to meet is that you habitually reside here. That's really it. That jurisdictionally, if you reside here, you're allowed, and you, not both of you needing to reside here. Let's say only one party lives here, you're able to apply for a divorce here. If that's the appropriate jurisdiction, makes most sense because this is where you reside, then this is where you start the process of getting a divorce.
Exactly. And the only thing I would add to that is just be mindful of where you start the divorce. So some people in trying to, there's more to it. So it's great that you can go get your divorce somewhere else. It may be faster. I do understand in some countries they require you to get the divorce there. Again, take that with a pinch of salt, but I have heard that from clients. But I think what I want people to be more mindful of are a couple of things. The additional relief you might be asking a court for. So if you go get divorced in Nigeria, for example, remember that a divorce is a divorce. You have 2 years from the date of divorce to make an equalization claims. So don't go get that divorce in a hurry somewhere else and completely forget about it and then think you can come, how many years later to ask for the division of the RSPs. You might have barred yourself from being able to do that. Support is a huge one. If you've gotten divorced somewhere else, you might not be able to apply for spousal support here, or you most likely wouldn't be able to. So keep it simple and do it here. If you think it serves you to do it in another jurisdiction, well, it is what it is.
Definitely get independent legal advice. That's all we're trying to say, is make sure that you're not defeating any of your other claims and ensuring that you're using the best, process to resolve your issues without, hindering the other ones that need to get resolved.
Absolutely. Perfect. So, I mean, in terms of the ways, how can a person actually put in their application, right? So you've decided you want to get divorced. You want to do it in Ontario. You meet the grounds. What's the process?
So really, there are three ways you can commence. You can start an application that really deals with not only divorce, but other issues such as support and parenting time and decision making and equalization. But if it's a very simple divorce where, you're married for a short period of time, or you don't have kids, or you're really not arguing about any property issues, then you can go with a simple divorce. And if you both agree that, okay, we're not dealing with anything and we agree to get divorced, then there's another form, the third one, that is joint divorce. I personally, in my practice so far, have dealt majorly with just simple divorce. And I really like a simple divorce because it is what it says. It's simple. Client contacts me, you get the application started. There's a timeline, like from the time that you file your application up until the date the time that your divorce become effective. It takes about approximately 91 days, but don't hold me to it, because once we're waiting to hear back from court, then, when things are out of our control, we can only move as fast as as we can. But really, it's simple. And then if the other party remains quiet, they essentially they consent to you getting the divorce, and you can go ahead and get your divorce certificate by the end of, again, 91 days, but sometimes it may take longer.
Yeah, honestly, I think sometimes it depends on the courts. We've had, well, joint applications that have taken like close to 6 months. So it really depends on where the courts are with things. And
Right.
I'm glad that you put that out there, because when we've done our part, we can only nudge a judge to sign off on it so quickly, right? But Sherine,
Exactly.
what's your preference in terms of the simple versus the joint
My
applications?
preference is the joint because it's very clear that each party agrees to get a divorce. With a simple divorce, you're just kind of just leaving it to the unknown that the other party is not going to contest it, claim other things. And sometimes it does get complicated, especially even if they want to deal with property and they want to deal with it in that specific process, they can respond to your application. At least with a joint divorce, you're both aware they're both asking for a divorce. There's no one contesting it, and then it goes in all at once. It's supposed to be faster in terms of timeline. And of course, it's cheaper because there's no prospect of whether or not this person is going to contest. And of course, the serving of the document, initial serving, is not going to be a process.
Okay, so you guys, you heard it. Two lawyers, two processes. They both have their respective favorites. So I think at the end of the day, it really depends on what serves you best, right? So I mean, while we might have a preference for joint, if you haven't spoken to your partner in the last 5 years, well, joint might not be a realistic option for you, right? So there's other factors besides just personal preferences. Or and I've had cases where both parties want the divorce, but someone for maybe religious reasons or otherwise doesn't want to appear as though they're applying for the divorce, or they want the record to be clear that X requested this divorce and it's not them, and posterity would have it that they did not ask for this divorce. So it doesn't matter in those circumstances. A joint would be easier. Clearly, they want it to be obvious that one person requested it, even if they don't contest. So, again, speak to a lawyer. If you have other claims, obviously, then you would go to the initial process that Tabindah talked about, which is just a simple application where we request everything, including your divorce. Okay, so let's say we're going with the option where you're requesting additional claims other than the divorce. What do you do where you have a client that actually wants to get divorced right away? Because we all know how slow the court processes can be. So, do you want to weigh in on sort of severing the divorce from the other claims?
Yeah, so if your claim for a divorce includes other claims, it's your divorce is not going to proceed unless the other party agrees to sever the divorce, which is keep the issue of divorce separate from the other relief that the other party or both parties are seeking, and just allow the divorce to proceed. That's an option. But again, that's something that the other party has to consent to, or the court can order. And again, sometimes this could be because you're either remarrying, maybe at this time of the process, it's been years since you guys have been separated. Yes, there's other issues that need to get resolved, but you just need to deal with the issue of the home. Just deal with the issue of the divorce. You can allow the divorce to proceed. The important thing to remember is that if there's children involved and, you guys don't want to deal with the issue, well, one party doesn't want to deal with the issue of the divorce, your divorce is not going to proceed on the basis without getting arrangements for support and the children's living arrangements resolved, even on an interim basis. They take priority over a divorce, of course. So support and the arrangements for the children are very important from a court's perspective. So you want to be mindful that these are issues that need to get addressed quite early on, if they are issues. Even if you guys agree to everything else, there needs to be a written agreement or a court order respecting the care and the support arrangements for the children prior to applying for a divorce.
Yeah, particularly support for the children is a huge one. You might be able to you could be fine without sort of firming up parenting arrangements, but if you're not providing if the children are not being provided for financially, that would be a hard sell to get a judge to sever. And by severing the divorce, understand that procedurally, when you bring an application asking for, say, divorce parenting time support, the normal course of events is for everything to lead to a trial or everything gets settled all at once. So this is, in this case, we're saying, well, we've not settled other things. It's not yet, trial time or whatever. We just want to take the divorce off these other issues, deal with it, and then the other claims continue. So if there's a disadvantage to a party, to the other side, then you will not be getting that divorce, right? So, what could be a disadvantage, for example? I mean, in some cases, it might have effects on the pension, on the division of a pension, for example. Again, may not be, I'm just throwing out factors that a court will think
Medical
about.
benefit.
Medical benefits is a huge one, right? There's some very few fantastic benefits that allow people that are divorced to remain on the benefits. But a lot of people, once they're divorced, then then they're no longer allowed to be on the plan. It doesn't mean just because you make that claim that then the person's automatically barred. There's ways to deal with that. If it's benefits, well, what if we pay and get you a private program for yourself, so you're no longer tied to your partner, your ex's benefits. So there's ways to deal with it, but we're just saying we need to deal with it. And so it's good to, if you're in the court process and you have a relationship and you're trying to get engaged and you want the big day to come soon, there might be some planning involved, and we can still help you get there. You don't have to wait years and years until it's over. But last thing, and this is something, Tabindah, I want you to kind of talk about this in terms of costs. Like, what kind of costs are people looking for when trying to deal with a divorce?
So I mean, it really depends on if you are commencing a simple or a joint divorce based on your separation agreement or an agreement. Generally, the rule of thumb is either both parties equally, if they on a consent basis, pay for divorce, or the party in an application asking for divorce pays for the divorce. So generally, that's the rule.
So there is the legal fees, obviously, and then there's the court fees, right? That we need to be mindful of when dealing with this, right?
Correct. Yes. Yes.
Okay. So yeah, and obviously if someone's trying to sever their divorce and you're refusing and they have to bring emotion to a judge to ask for it to be severed, well, that's a whole other cost conversation. But just know that if you're asking us as your lawyers to prepare the divorce applications for you, there's a cost to that, and you need to have a conversation around whether it's being shared or if the person that's starting it is paying. And you both need to be mindful of court fees. I think at this point, Sherine, correct me if I'm wrong, I think it's about $600 and something right now.
$632 to get the initial filing for divorce if you want a certificate.
This is to
the normal course where nobody's disputing the divorce. It's just the matter of a divorce. The court filing fee is $632, and if you want a divorce certificate, the current price is $25.
Oh, I remember when it used to be 19. Okay, so inflation. Guys, that's a different other conversation as well. But yes, I'm not sure if anybody has anything to add. Just trying to keep this as high level and as simple as possible. And I hope we've accomplished that. And until next time, it's bye for now.
Bye.
Bye.